subscription database, literally anything in some company house. This is God, we trust them linked to all the company house. This is like a pretty good company.
Hello, can you hear us? Okay.
Yes, I can hear you. Hear me?
Yeah, we can hear you as well.
Perfect. Thank you.
Okay. Hello, everyone. Thank you so much for giving up some of your afternoon, evening with us. For joining us for Legal Voices to the Future's November, our first November knowledge session, actually, as we've got two this month. We're here today to talk about investor state arbitration and climate change disputes. And we're also really excited to be back here at LSE with the Grantham Research Institute because it feels like a long time since we've last been here, and we're always very grateful to GRI for hosting us and to you, Emily, as well, for all of the ongoing tech support and background help that will no doubt happen throughout the evening. So thank you. Just a little bit of housekeeping before we kick off. If anyone needs to go to the bathroom, if you just take a left out of this room and go down the corridor, then you'll be signposted to where you need to go. Similarly, if you need a drink, there's water fountain just down there, or there's a kitchen just in there. If you take a glass, please wash it up. Don't leave any mess for everyone else to clean up afterwards. If you hear the fire alarm, to confirm, it is not a drill. It is a real fire alarm. So just keep calm, follow us. We know where the emergency exits are. Leave all your belongings and just, yes, keep calm, follow us. The session is being recorded this evening, and you might see some of the committee members walking around taking photos. If you're not comfortable being in photos this evening, that's perfectly fine. Just come and grab one of us, tap us on the shoulder, let us know that you don't want to be in any photographs, and we'll make sure that that happens. We're running a Slido. You'll maybe seen the code. We'll also share it later. If you've got any questions that you want to ask our fantastic panelists and our fantastic hosts this evening, please put them through Slido for us and we'll go through them. Although if you also want to do it the old-fashioned way by unmuting yourself online or putting your hand up in the room, please do. We love audience participation. It makes the evening better for everybody. And that's it on housekeeping. So thank you for joining us, as I said, and I can see that we've got some new faces in the room this evening. So thank you, and thank you to everyone who's a repeat attendee of our LVF events. It's lovely to see you all here. But if you are new and it's your first time here, just to let you know that what we do briefly, I'm Riley. I'm one of the Stewardship Committee members. I've been on the committee for nearly 3 years now, and it has been an absolute pleasure. And LVF, we are an organisation run by junior legal practitioners across the practice of the city, barristers, trainee solicitors, lawyers, academics, and we are run for exactly those people. And our goal is to educate the legal profession on the climate and ecological crises that are facing our world today and are two of the biggest pressing issues in our world. And the main way we do that is by hosting evenings like this evening with our monthly knowledge sessions, and they are free to join, as you know. And we also have community events because, as I said, we've got repeat attendees. It's nice for us to build a community of people who are getting to know each other, who share similar values and similar, practices and want to get to know each other. We also have a members-only newsletter. We host members-only webinars, and we have a blog. And as I said, everything's being recorded. So if you want to go back and listen to anything later on, or you want to listen to any of our sessions that we've hosted in the past, you can watch them on our YouTube channel. You can find all of this on our website, which is easy to find by searching Legal Voices for the Future. And as I said, we're really grateful to GRI for hosting us again this evening. We have an ongoing partnership that we are so grateful for. And Emily, we're so grateful for you, as I said. And if you want to find out more about the Grantham Research Institute, you can scan this QR code and get access to their newsletter. You can also grab Carol or Emily, who also work at GRI on the climate law and governance team. Grab them, they're very friendly, they're always willing to chat. And yeah, we're very grateful. And that is all from me. I won't take up any more of your time, Carol. Looking forward to it. Thank you.
Thanks, Riley. Hi, everyone. So you want to clap for her? I'm Carol. I'm a Stewardship Committee member here at LVF, and today I'm joined by my co-host, Xiaohan, who is a Senior Associate in the Litigation Controversy Department at WilmerHale. Our knowledge session normally comprises of 3 components. So first, we have a creative content to make us reflect on how we think and how we feel about the topic, and it will come with a group discussion as well. Second, we will have a presentation, a short one, to introduce us to the topic. And third, we'll have a panel of experts to share with us about the topic. First today, we'll have the creative content. It's a clip from a documentary called The Tribunal, which will allow us to see how local communities in Ecuador are impacted by the environmental changes and the investor-state arbitration process by a copper mining company. We hope that this clip will arouse your interest in the topic and allow us to think a bit more about the implications of investor-state arbitration on the environment as well as the people during this evening. Then we will have a presentation from Xiaohan, followed by the panel, which Xiaohan will introduce later. We'll then take a short break and we'll have breakout discussions later. We hope you stay for the discussions as well so that we can share our thoughts and get to know each other. And at the end, we'll have a pub social. Hopefully you'll join us for that as well. So right now I'm going to play the clip from the tribunal. It will be about 10 minutes.
Sorry, everyone, just some tech issues. I think why don't we share? Yeah. Is it the 969
Sorry, everyone, there's always a tech issue.
one? New one each time.
I think after COVID, we've all learned how to deal with these things eventually.
On this note, we're gonna stop here, but if you are interested in watching the rest of the documentary, there is a link available in the emails that we've sent you. Hopefully that was useful for giving an insight into how local communities might be impacted. And later on, I'm sure we'll also discuss how local communities might or might not be involved in the arbitration process. So now we'll move on to the more legal bits of the day, and I would like to invite Xiaohan to come on for the presentation. Hi, everyone. Oh. There you go. Hi, everyone. Thanks again for spending your Wednesday evening with us here today, both in person and online. My name is Xiaohan. I am co-hosting the session today. And for the next 10 minutes or so, and I'll just maybe ask Carol to help me keep track of the time, because I think we're overrunning a bit. But for the next 10 minutes or so, I'm going to provide a very, very quick introduction to investment arbitration and climate change, so that we have some understanding of the issues before we go into our panel discussion with our experts. So maybe just a show of hands so that I know how much detail we can go into later. How many people in this room have had experience in investment arbitration before, either like you studied it in school or you practice it today, or you practice it in the past during your training contract? Okay, so like basically most of the people on this side and a few people on this side. Okay, that's actually really helpful because I think then we can go into quite a lot of the detail later. Okay, so then I'll just move really quickly because then a lot of this will be just quite basic to most of you. As you would have seen from the clip earlier, investment arbitration, also known as investor-state dispute settlement, is a legal process that allows foreign investors to bring claims against a host state, typically under investment treaties. And this would arise where the investors believe that their rights, such as to fair treatment or protection from expropriation, have been violated. So the key features here are that the claim is brought under a treaty as opposed to, say, domestic law. So this distinguishes it from other processes such as litigation. And these treaties can be bilateral investment treaties or free trade agreements or broader investment and trade agreements such as the Energy Charter Treaty. It's a system that allows foreign investors to sue states directly. And instead of going through domestic courts, these claims are decided by independent arbitrators, typically sitting as a tribunal of three. And we can go into things like arbitrator selection process later. So the reason why we wanted to talk about this at a knowledge session is because investment arbitration has come under quite a lot of fire in recent years for being allegedly opposed to states' climate commitments. And this is something that we'll discuss later during the panel discussion as well. And we'll quickly unpack why some people say that there is a conflict. The main criticism of ISDS in relation to climate change is that it causes what we call regulatory chill, where there's a hesitation or avoidance by governments to introduce regulations such as climate policies due to the fear of being sued by foreign investors under ISDS mechanisms. So one example is New Zealand was designing its ban on oil and gas exploration. And it's reported that during this time, the government was aware of the growing number of ISDS cases targeting environmental regulations. And due to concerns about potential risk of being sued in ISDS, the New Zealand cabinet chose to limit the ban to offshore exploration and allow existing licenses to remain in place. Another example is in Germany, Vattenfall, which had an agreement with the regional government of Hamburg in Germany to develop a coal-fired power plant, commenced an investment treaty dispute due to Hamburg's environmental protection restrictions on the investor's water use permit. And to settle that dispute, Hamburg eased the environmental restrictions attached to the permit. So these are some of the, I think, many examples where it's been reported that because of a potential or crystallized risk of an ISDS claim being brought against the state, a state has retracted or toned down on their environmental policies. And that is what we refer to when we talk about regulatory chill. Something that is very particular to the climate crisis are measures taken to phase out coal. And this is of particular relevance to the climate movement because coal has been recognized as the dirtiest fossil fuel and the first that must be phased out. And as of today, over 180 countries have joined the Powering Past Coal Alliance, which is committed to phasing out coal power without carbon capture and to stop building new coal plants. But many governments face the possibility of investor-state claims if foreign investments in coal are affected by these government actions to phase out coal. And so governments in the Netherlands, Germany, Canada, and Australia, just to name a few, have been asked to pay billions or millions of dollars in compensation in response to actions that these governments have taken or proposed to take to phase out coal. On the screen here, I've listed some other criticisms of ISDS, which we will go into in detail later as well during the panel. The first two are confidentiality of proceedings, as well as the ability of third parties to participate in ISDS proceedings. So for those of you who watched the tribunal documentary and watched the full thing, towards the end, you will see that some of the individuals who were part of the INTARC community were actually asked to attend the hearing in the arbitration in Washington, D.C. And their experience was that they were asked to put in witness statements and they were asked to fly all the way to DC to attend the hearing, but ultimately their testimony wasn't heard in the oral hearing. And it's unclear whether or how much weight the tribunal gave to their lived experiences. And so the criticism of ISDS is that it being very confidential proceedings and with very limited ability for third parties to participate means that the public, including communities directly affected by actions of the foreign investor, often don't know about these proceedings. They don't know the details. When the award is issued, it's most of the time it's in English, which might not be a language that these communities understand. And they are not given an opportunity to have their voice heard in these proceedings. The third point on the screen on arbitrator selection is also criticized in relation to ISDS. The tribunals deciding the legality of a state action are often not diverse, and they may not have expertise on the issues that impact policy making. Just earlier today, as I was preparing for this panel, I came across a quote from Sadia, who is joining us remotely, and she'll speak later on the panel. But Sadia made an observation that although 15% of investment arbitrations concern African states, the proportion of arbitrators of African descent hearing ISDS cases is much lower than that. And I think that that's quite a legitimate concern in terms of whether or not these arbitrators properly represent and are able to decide cases based on a holistic view of the issues before them. There is also limited availability of counterclaims. Lucia, who will be speaking on the panel later, published an article in 2023 which observed that the number of counterclaims brought by states against foreign investors remains low. The vast majority of such counterclaims have failed on jurisdiction or admissibility, and there are only 2 known counterclaims that have succeeded on the merits, and this remains the case today. And those 2 counterclaims only succeeded because the investors in those cases agreed to the tribunal's jurisdiction to decide on the counterclaims. Again, quoting from Sadia from her 2024 panel, she said that states never win in ISDS, which I think rings particularly true when we talk about the availability of counterclaims. The most that a state will be able to gain for itself in a claim would be the dismissal of all claims, as well as for the investor to bear the costs
of the state defending itself. And lastly, on damages, this is a very complex topic. Oliver, who is on our panel, and Judy as well, will be speaking about it later. Oliver in particular has written extensively on the topic, which I will recommend for anyone who has interest in this very, very complex topic. But to distill it in maybe 2 sentences, the position that's often taken by the investor in fossil fuel phase-out cases is that they are entitled to future income from the asset that has been expropriated. And the method by which these claims are calculated, I think there are a range of methods, and there are various considerations, not just what standard to apply, but also whether or not the investor has proven causation and so on. But the most common method for investors to bring forward in their claims is what we call the discounted cash flow method, DCF, which essentially calculates future income of the asset that will be generated had the asset not been expropriated. All that to say that these methods that are used to value damages in these claims often result in the claimants asserting a claim for millions or billions of dollars against the state. I think multiple articles have pointed out that these claims often are larger than the state's GDP or the amount of money that they have available to spend on environmental regulations. So amongst these criticisms, there have been many ongoing reforms. I've listed a few of them here, and I don't think we'll have enough space in today's panel to talk about all of them. But it is exciting times, I think, for investment arbitration, because many of these reforms are ongoing in parallel, and whether or not it will succeed in dealing with some of these criticisms, or whether or not they've already succeeded, is something that we will discuss later today as well. The other notable development that we'll explore would be the impact of advisory opinions and decisions from international courts as well as national courts, but more importantly, the decisions by the ICJ and other similar tribunals and courts that have been asked to render advisory opinions on a state's climate change obligations, and how that would impact on an investment tribunal's decision. That's something that we will explore today at our panel as well. So with that, I would like to invite our panelists to take the seats in the front. And with all of you seated, I'll introduce the panel. And Sadia, maybe if you could, I think you can turn your camera on now. I will join you in a second. Hello? How does... Hello? Are the mics on? They're on. Okay, sorry. So I'll start off by introducing Sadia, who is on the screen and joining us from Washington, DC. Thank you so much for joining, Sadia. I know you're traveling for work, and you probably have a really packed schedule. Sadia is a partner and co-head of GDA's International Dispute Resolution team in London. She specializes in international arbitration and public international law. Particularly exciting for today's panel, Sadia was part of the team that represented the African Union in the ICJ advisory proceedings on the obligations of states in respect of climate change. And she's also currently part of the legal team representing an African state in the advisory proceedings before the African Court on Human and People's Rights on the obligations of African states with respect to the climate change crisis. Sitting in the middle, Judy Fu is a commercial barrister. Sorry, Carol.
Sorry.
Thank you. Judy is a commercial barrister at 3 Verulam Buildings with wide litigation and arbitration experience. She has acted in disputes concerning oil and gas, upstream and downstream, renewables, mining and metals, and commodities trading industries. She has also acted for and advised both companies and non-governmental organizations on ESG, energy transition, climate risk, and decarbonization issues. Notable cases include Kleinef and Shell and the PAN-NOx emissions group litigation. Just next to me, Dr. Oliver Hills. Dr. Hills is an assistant professor at LSE Law School, where he teaches and researches international law and arbitration, including energy, investment, and environmental law. He is also an associate of the Grantham Research Institute, who is hosting our venue today, and assistant general editor of the Exit Reports. Oliver holds an LLM and PhD from the University of Cambridge and was previously a lawyer in New Zealand. And lastly, Lucia. Lucia is an associate at WilmerHale in the International Arbitration Practice Group. We actually sit a few doors down from each other. Her practice focuses on commercial and investment treaty arbitration. Lucia has represented clients from different sectors, including energy and ESG, in institutional and ad hoc arbitrations under a variety of arbitral rules. She's also a member of the Young and Young at Heart subcommittee, which co-organizes the annual London International Disputes Week. And with that, thank you very much for our panelists for joining us today. And I'll start off with the very first question. So maybe just for our audience's benefit, we have prepared 3 questions. Each of our panelists today will take the lead on one of them, and they'll speak on the issue for about 9 to 10 minutes, and then we'll have the rest of the panelists respond. And at the end, there will be an opportunity to ask questions. So I highly encourage you, for those in the room, to save your questions for later. For those joining us online, I think there's a Slido where you can submit questions, or if not, you can just ask them by Zoom afterwards. Okay, so our first question for Sadia, who has disappeared. Oh, I think Sadia has slides. Okay, our first question is, in recent years, we have seen advisory opinions and decisions issued by courts, such as the ICJ, the ICHR, and the ECHR, discussing states' obligations to meet their climate commitments. And how do you think investment arbitration tribunals will take these into account in deciding cases involving environment or climate-related regulation?
Thank you very much. Can you hear me okay? Yes?
Yes.
Thank you very much for the invitation, and my sincere apologies for not being able to join you physically today. I'm especially sad to miss the pub afterwards. I will answer your question, but before I get into it, I know a lot of people have background in investment arbitration. I saw the show of hands, but I thought I'd give you a little bit of background on what's going on with respect to those advisory opinions that you were mentioning. So I'll give a little bit of background in those 10 minutes, and then I will talk about the impact that it will have, in my view, in investment arbitrations. Now, with respect to the ICJ advisory opinion on the obligations of states arising out of climate change, you saw a snapshot of the documentary, The Tribunal. I think I cannot not mention the role played by Vanuatu, which is a small island state in the middle of the Pacific. That was at the origin of these proceedings. I think it's important for you to know this, not least because there's a lot of people that are very young in the room. I know that one of our panelists is also chair of this very young committee, and I know a lot of you are either already young lawyers or aspiring young lawyers. This all started not only by Vanuatu, but actually young students. There were 27 students in a room like this one in Vanuatu listening to environmental law lecture, and they decided that they wanted to do something about what was going on, simply because Vanuatu is going to disappear clearly, and just, it's just an existentialist threat to a small island state, what is going on with climate change. And so they actually convinced the government of Vanuatu to convince other state members at the UN to issue a UN resolution. So I just wanted to spike 1 minute about this because it shows the power of the community in making law. So that's important. Here you have Cynthia Hunihi, who is a young, she must be 20 something. She was speaking at the ICJ that day, and her speech is online available. So if you're interested, you should really listen to all oral submissions at the ICJ. And she was speaking on behalf of Wanatualong with the delegation. Now, what was asked before the ICJ, and that's the legal matters, there were two questions that were posed to the ICJ through that UN resolution. The number one was, what are the obligations of states under international law to ensure the protection of the climate system? And I'm going to stop quoting here, even if the other words are really important, because you've got it under the screen. So basically, number one, what are the obligations? And number two was, what are the legal consequences under these obligations? And here you would see that there's language that is very important because there is reference to significant harm to the climate system and other parts of the environment with respect to, in particular, and that's the first bit, small island developing states, and particularly vulnerable to the adverse effects of climate change. And number two, peoples and individuals of the present and future generations. Again, a mention to how important it is to take into consideration just people, generally speaking, as well, and those who are the most vulnerable under climate change. Now, it was a historic proceeding, and I think it's really important to mention that because there has never been in the history of the ICJ so many states that have participated. Okay, clearly and simply. And you have a total, maybe my count is a little bit off because it changes depending on how you count, but I counted 112 participants, including 13 organizations. You've got a breakdown here. You've got a map that shows who participated orally only with written submissions, and both. And you've got a list by countries here. I'm just going to skip through it. It's just for your own reference if you want to have a look, and the list of the organizations that participated. And you can see here, of course, there's the African Union that I represented, but so many others, including the Pacific Community, the Alliance of Small Island States, the European Union, and so on and so forth. Now, this was in the context of other advisory opinion, and it's also important to mention it doesn't happen individually. There were actually another advisory opinion that had been requested at the Inter-American Court of Human Rights on the obligations of states under that treaty, and in front of the International Tribunal for the Law of the Sea as well. Okay, the Inter-American Human Rights opinion was rendered 29th May 2025. So literally less than 2 months before the ICJ advisory opinion, and the advisory opinion under ITLOS was rendered a year before. And of course, there are references in the ICJ advisory opinion to both of these advisory opinions, which is really interesting. Okay, now why are we talking about this today in terms of the impact on private actors, and private actors meaning foreign investors? Well, because there were several submissions that not only in responding to those two questions, they actually emphasized and requested the tribunal, the court, the International Court of Justice, to declare that states had an obligation to regulate private actors, especially in the fossil fuels industry. Okay, and that is what is significant here, is because there were a direct impact on what states have to do to lower greenhouse gas emissions, and it cannot happen without regulating private actors. Now, what did the ICJ decision say then? Now, please bear with me because it's a 140-page decision, okay? And I only have a few minutes to summarize this, so this is not exhaustive, but I'm giving you the key points. States have binding erga omnes duties. What does it mean? Is that they have binding international obligation duties that are to everyone. They're not just to a specific states, but to the entire community. That's what erga omnes says, okay? And it's not just mere political commitments to protect the environment. That's how sometimes the Paris Agreement and the UNFCCC have been interpreted. Okay, so they're real obligations they're binding obligations. The ICJ also applied the principle of what is called systemic integration. What does that mean? It means that you are to refer to the entire corpus of international obligations applicable to states, which move way beyond just climate change treaties. So there was a series of states, mostly the most polluter states, that said, okay, we have obligations, but they're only under climate change treaties. So the Paris Agreement, UNFCCC, Kyoto Protocol, and so on and so forth. And there was a whole other bunch of states, the majority of states, that were saying, no, hang on, we have obligations under international human rights, under customary international law, under law of the sea. And in fact, the question that I showed you earlier, at the preamble of the question, all of these legal obligations were referred to by way of example. And that is also significant because the ICJ said, yes, there are international obligations under treaties and environmental obligations, but way beyond this, also under all of these laws. Now, clearly and simply, the state also said that they must take adequate, and the ICJ said that the states must take adequate and effective measures to prevent significant environmental harm. It also explained the concept of common but differentiated responsibility, CBDR, which is that all states have a responsibility, okay, to do this, but developed countries that because of their historical emission have greater liability, and so they have a stronger liability with respect to that. Okay, so you can't expect, putting it simply, you can't expect African states and small island states like Vanuatu to be held liable the same way as say the United States, which is historically the highest country that has highest emissions historically, and so that is also very important. Now, the second part of the question was, what are the legal consequences? Well, failure to do so may be qualified as a wrongful act, and state liability may be invoked, to put it very simply. Now, here I have a few slides, because I know I'm running out of time, that are excerpts from the ICJ opinion specifically, so you can have a look at what it says, because words do matter, okay? And it says that states are required to take proactive and pursue measures that are reasonably capable of achieving the NDC set by them. These measures may include putting in place a national system, including legislation, administrative procedures, and an enforcement mechanism, and existing adequate vigilance to make a system function effectively, okay? And that is very important. Now here also at paragraph 403, you will see that these measures, the court said, may include taking mitigation and adaptation measures with due account giving to the protection of human rights, the adoption of standards and legislation, and the regulation of the activities of private actors. Here it's written specifically that there is a regulation of private actors. Now, the implication for corporate entities, and more specifically on the fossil fuel industries, has also been mentioned. At paragraph here 282, the ICJ says that these rules and measures must regulate the conduct of public and private operators within the state's jurisdiction or control, and be accompanied by effective enforcement and monitoring mechanism to ensure their implementation. Now, I know we're going to speak about it later today, but in the investor arbitration world, there is, when we talk about regulation, we talk about a state's right to regulate, okay? The foreign investors bring a claim, and the state in defense will raise the right to regulate, okay? Here, clearly, in international law, there is this duty now to regulate, to prevent environmental damage. And here at paragraph 427, it is clear that the failure to fulfill these obligations, including against fossil fuels, may constitute an international wrongful act, which is attributable to that state. Okay, and here you've had the reference here in yellow that I've included, and it's really important that the court went all the way there. Now, just a practical example, you're like, okay, all of this is really cool, but what does it mean concretely speaking? Concretely speaking, there are various tools that the state must put in place. One of those is an environmental impact assessment, also known as here it's EIAs, and it says that it is important that all states provide for and conduct EIAs with respect to particularly significant proposed individual activities contributing to GHG emissions to be undertaken with their jurisdiction or control on the basis of the best available science. Science had a key role in these proceedings, okay? There were scientific experts that were auditioned by the court, and there are such things called the IPCC reports that were put into evidence. A lot of states actually attached expert reports, and so it was taken into consideration. So what the court here is saying is that when there is, for example, a fossil fuel industry or a mining company, an oil energy company coming in the state to do some exploration, they should require from them an environmental impact assessment, which is based on science. Now, I've spoken a lot about these advisory opinions. And again, it was a very quick summary, so please bear with me. I know I've forgotten probably a lot of important things, but you got the gist of it. Now that we have this, what's the impact on investor-state arbitration? This is the core question today, right? And before I go into this, again, I think it's important for you to visualize why we're talking about this, because where you have an investment project, this is a chart that I've been using for 10 years now. There's a really cool article, Foreign Investment Law and Sustainable Development, that I've referenced here. And it's a report actually by IAED. And it shows here the investment project, all the different regulations that affect an investment. And here you see that it is impacted by national law. It is impacted by the contract, of course. It is impacted by other, industry standards and guidelines and so on. And of course, it operates under international law. And one of here you see, it says investment law, tax treaty, human rights law, environmental law. And with the ICJ opinion, human rights law and environmental law will be part of the whole environmental of legislation that a tribunal must look at, because it is applicable to the states, in addition to investment law, strictly speaking. And that is, I think, the most interesting thing that's important. I'm going to skip that. I just wanted to do an intro on what is international investment arbitration, because I was told that maybe some of you do not know what it is. So I'm going to skip, and Xiaohan did a really, really good presentation. What's important to know in terms of investment arbitration cases that concern the environment, it's that these figures here are telling. Approximately 62% of fossil fuel investments are covered by investment treaties. What do I mean by are covered by investment treaties? That they are regulated. In fact, they fall under the regulation of bilateral investment treaties. And these bilateral investment treaties give a lot of rights to investors, no rights to the state. That's kind of how they're drafted, okay? And the scale of potential claims is substantial. It's about $340 billion of ISDS claims that relate to questions surrounding the energy transition alone. These figures are really, really important to keep in mind, okay? Now, if you want to prevent those claims in the future, because they are going to keep happening, states must adopt environmental protection measures in line with the advisory opinion, potentially impact foreign investors. So this is going to happen because to protect themselves from liability at the international level. And so to prevent those claims, they have to reform their treaties as well. That is, and Lucia is going to talk about this, so I'm not going to go into much detail about this. Here you will see just stats as to the evolution of cases. That's only under 2021. And believe me that from 2021 to 2025, as of today, these numbers have really, really exceeded what we would have expected in terms of the number of environmental cases. Now, in the ICJ opinion itself, in fact, there is reference to what Xiaohan mentioned earlier, which is the regulatory chill, okay? Because a lot of participants mentioned it. And here you can see here, in fact, sorry, it's in the separate opinion of Judge Cleveland that this except. It's not from the advisory opinion itself, but I still think it's very important. And you'd see here paragraph 21 and 22 references to the regulatory chill and the negative influence of international investment law. And then in paragraph 22, she says, accordingly, the interpretation of investment instruments must be informed by states' obligation in respect of climate change under international law, including the stringent due diligence standards to which states are bound in implementing such obligations, okay? So I think what she's saying basically is what I told you earlier, is like when you are interpreting the rights of investors and maybe the right to regulate in the terms of investment arbitration of the state, you cannot do so without taking into account all these other obligations, especially those that have been mentioned now by the ICJ itself, okay? So again, with respect to the investment treaty reform, we're going to talk about this a bit later, but I did wanted to talk about it here because it is part of the puzzle. For states, and here this is a quote from the Inter-American Human Rights that say that states should review their existing trade and investment agreements and do not limit or restrict efforts relating to climate change and human rights by reviewing those treaties. So this is extremely, extremely important. Now, one question that is often asked is, okay, all right, so tribunals are going to look at the advisory opinion because now environmental obligations are not just rooted into, a climate change treaty per se. They're also erga omnes, with the weight of erga omnes. But it's an advisory opinion. I mean, why would a tribunal look into it? It's not a decision. What weight does it have? So it's not binding, that's true, but it definitely clarifies obligations and responsibility. It will have a direct impact not only on the reasoning of international tribunals, but on the reform or renegotiation of investment treaties and domestic law. And there will be specific references also made by domestic courts. In fact, there was a speech just about a few days ago from the president of the ICJ. I don't know if you guys have seen it, but if you haven't, please have a look. It's online. And he mentions, in fact, Judge Yuji mentions this, like all the court advisory opinion, it is not legally binding. However, and he quotes Judge Grosshair, once observed, it seemed to be generally admitted that the distinction between the court's judgments and its advisory opinions cannot be taken too far. When the court replies to a request for an advisory opinion, it does not transform itself into a committee of 15 legal consultants. It continues to be the principal judicial organ of the United States. I think there's no better way of the United Nations. Sorry, sorry for that. For saying that. I think some people would wish that it would mean the United States, but it's the principal judicial organ of the United Nations. And so, what does that mean? That means that the advisory opinion has an impact, and it has weight, and it will definitely be referred to by international tribunals. And in fact, I don't have put the slides here because it was too heavy, but I have multiple examples of investment arbitration awards that make reference to advisory opinions, not this one, but previous ones with respect to different standards. So I do not see how this will not happen with this landmark decision now today. So just to conclude, I mean, just a word of conclusion maybe. I will say that definitely international tribunals will now incorporate this decision. I know there are some pending matters where this decision has been produced. Okay, that has been produced by some parties, and states will rely on it for their right to regulate. They will rely on it for their defense, and tribunals will refer to it in their interpretation of the rights and obligation of investors, even in those cases where the investment treaties do not refer directly to environmental obligations or lay out those duties that Lucia will be talking about later. So, there'll be impact on not only investor arbitration, but also state-to-state disputes, and on commercial arbitration as well. And I haven't spoken about this, but we can talk about it later if you have some questions. I'm going to stop here because I know I've used all my time. So thank you very much for your attention, and I'm here to take questions later today. Thank you.
Thanks so much, Sadia. I'd like to invite our panelists to see if they have any responses, comments.
I'll make a quick comment, which is also if you're interested in the issue of fossil fuel investments and phase-out measures, it's worth looking at Judge Bandari's the duty of cessation as a consequence of state responsibility probably requires states to discontinue practices that are causing significant harm to the environment through greenhouse gas emissions, including fossil fuel production. So this declaration hints at the phasing out of existing fossil fuel infrastructure, not simply the prospective integration of climate change obligations in instruments like environmental impact assessment.
Thanks, Oliver. I thought that was a great presentation by Sadia. I actually now have more questions than answers because, how do you balance the obligations of states in relation to, they have to regulate, but at the same time, I'm sure they're also caught in a bind because the old generation of BITs are still in force. A lot of them still cover the fossil fuels. And I don't think we have enough time to go into that, but I thought that was a really, really good presentation. Thanks so much, Sadia. And and I think that leads on very nicely to what Lucia will talk about, which is the ongoing discussions and reforms to the ISDS system. And Lucia, if you could talk about how the new generation of treaties address the backlash against investment arbitration in the context of the state's climate and environmental policies, and whether or not they've crystallized into any new generation disputes that you have seen and how tribunals have handled them.
Thank you, Xiaohan. Before I start, I wanted to thank the organizers, Legal Voices for the Future and the Grantham Research Institute for having us tonight and organizing this wonderful panel, and for inviting me to speak as well. It's a great pleasure. And your question and this topic I was asked sits at the intersection of two major themes which are hotly debated in arbitration at the moment, which is climate change and also the backlash against the investor-state arbitration system as a whole. And this in and of itself is also, thank you. And this in and of itself is also something which we could spend the whole panel debating, so I'll try to be as brief as I can. So let me first try to contextualize the new generation treaties and what the new generation actually means. The first wave of investment treaties is what we now call the old generation treaties, started to emerge in the 1950s and 60s. And the states at the time concluded these treaties to signal to each other that they were open for investment and that they would offer favorable conditions for foreign investment to investors from the other country. But they were often short, investor-friendly, vague, and as we've already heard earlier, they said very, very little, if anything at all, about the state's rights to regulate. Now, fast forward to the post-Paris Agreement era, and the arbitration community has had the benefit of seeing the ISDS cases play out for 40 years or so, and has seen the limitations of some of these old generation BITs. And more importantly for us today, climate change as a topic has also become a major cause for concern for many states. And essentially it's this context which has seen a proliferation of new treaties since the mid-2010s, and we offer to these new treaties as the new generation treaties. They are varied and very different in its form, but some of them and many of them share some significant common features. To give you a better idea of the scope of this reform we're talking about, according to the UNCTAD, which stands for the United Nations Conference on the Trade and Development, UNCTAD estimates that approximately 500 of those new generation BITs have been concluded since the 2010s. However, many are not yet in force at this time. That said, they do introduce a lot of very novel provisions which are not seen or which haven't been really done in the old generation BITs, and including some provisions which target specifically environmental and climate change sphere and even human rights. So let's now turn to some of these new treaties and some of the novel language. There's different ways of classifying this, so to speak. Different commentators and publications will kind of put this into different categories. So I picked 4 categories, but this is not set in stone. You can look at this in many different ways. So the first kind of type of novel provisions I wanted to share with you and show you is the novel preambular language. And that is important because that's going to inform how the whole treaty is going to be interpreted. So there's a couple of examples on the slides, but I want to point to the Norway's model BIT, which makes reference to external international instruments and states that the provisions of this agreement and provisions of international agreements relating to the environment shall be interpreted in a mutually supportive manner. Now, as a second example of different type of novel language, these go into substantive provisions related to environmental protection or climate action. And this actually connects to something Sadia mentioned, which is the environmental impact assessment. It's not what I have on the slides, but for example, many of these treaties, including, Carol, can we see the next slide, please? Many of these treaties, including the Nigeria and Morocco BIT, which is going to be on the next slide, so let's just leave this, includes an express obligation of conducting the environmental impact assessment, but for the investor. But anyway, speaking of the substantive provisions, I wanted to highlight provisions which go to the scope of the state's rights to regulate. Can we go 2 slides back? Sorry. So the state's right to regulate, which now is laid out expressly, and in many of these cases, very specifically with respect to environmental protection and climate change. And Morocco, Nigeria, BIT, which is in Article 13.2, recognizes the importance of environmental laws and policies and preserves the parties' discretion to regulate and enforce environmental matters, including those, as highlighted in yellow, determined to have a higher priority. And some legal commentators have suggested that this language means that this is above the investment protection. Now, a third example of different treaty language which these new generation BITs are introducing relates to the substantive protection. Substantive protection. This concerns clauses such as the fair and equitable treatment, FET, expropriation, most favored nation, umbrella clauses, and many others. I unfortunately don't have the time to go into all of these, so let's just pick the FET clause as an example of this. Modernized treaties, unlike all generation treaties, define FET more narrowly, and they will list specific types of state conduct in a much more narrow way that may breach an obligation of providing fair and equitable treatment. And a good example of this is the amended version of the Energy Charter Treaty. And spoiler alert, I will get to the Energy Charter Treaty later. But this FET language mentions measures such as targeted discrimination on grounds such as gender, race, or religious belief, but also fundamental breaches of due process or denial of justice. It also provides a much more narrow scope for investors' legitimate expectations, and as many of you who may have worked with ISDS before and done some cases on the FET, under the old treaties, the legitimate expectations can be interpreted in a very, very broad way indeed. And then a final, and I forgot to mention one quick thing. Some treaties go even further and remove the obligation of FET altogether and no longer include an FET clause. Some do this with expropriation as well. It's not too uncommon these days to see new treaties which just don't include any expropriation clause at all or much more narrow. But anyway, a final example of a treaty innovation which the new generation treaties are bringing is an imposition of obligations that are put specifically on the investors. And this is really big and one of the major innovations, because I think in virtually none of the old generation treaties there would have been any obligation on the investors. It was always only about obligations on the state. So treaties imposing obligations on investors is a major development. For example, the 2016 Pan-African Investment Code contains an entire chapter on binding obligations on investors, including the environmental impact assessment I already mentioned, and Sadia also did in her presentation. And with respect to obligations lying on the investors, some treaties go further and incorporate provisions that allow states to bring counterclaims. And this is major because, as Xiaohan has said in her presentation at the beginning, there have been attempts thus far by the states to bring a counterclaim, but only two succeeded in Perenco and Burlington against Ecuador, as you have mentioned. So I won't go into that any further. But one thing I wanted to flag is that those two counterclaims in those two cases succeeded only because the investor agreed to submit to the jurisdiction of the tribunal for the counterclaim. If it hadn't, the tribunal might have decided differently, all the more so that this was more than 10 years ago, I think, that the decisions have been issued. However, despite the fact that there are now new treaties which include the counterclaim provisions, such as those on the slides, some of the cases in recent tribunal practice are also showing that tribunals are increasingly open to hearing counterclaims. And one such example is Aven and Costa Rica. And the counterclaim Costa Rica in that case brought was related to allegations of investor causing damage to the environment. And crucially, the tribunal in that state found and held that the investor had obligations to protect environment under national law, but also under the treaty. And it also expressly found that the investor could be made subject of international law in this forum. However, and some commentators have said that this was a missed opportunity, the case ultimately failed because Costa Rica failed to comply with procedural requirements for bringing a counterclaim. So it couldn't proceed there, but the tribunal definitely left the door open. Now, a final point I will make very quickly before concluding is in respect of the Energy Charter Treaty, which again was mentioned in the presentation as well. This is important because the Energy Charter Treaty, I don't have any more slides, so we can just have Sadia back again. So this is important because the Energy Charter Treaty is the treaty which was invoked the most frequently by investors in 172 times as of the end of 2024. And according to some of the critics of the ECT, it protects fossil fuel investors. Now, I'm sure many of you will know that the reform of the ECT was very challenging, really not straightforward for reasons I unfortunately don't have time to go into. But the bottom line is that amendments were agreed and passed and started provisionally applying as of the 3rd of September 2025. So this is also very recent. And one of the most controversial, but also most hotly anticipated provisions of this new amended ECT relates to the fossil fuel flexibility mechanism. And this is very complex. I also know I'm running out of time, so I'll just really summarize this and simplify it maybe way too much. But what this does, this fossil fuel flexibility mechanism, is that it sets a different regime for investments in fossil fuel, depending on when those investments were made, in which state they were made, and what kind of fuel, or if it's fossil fuel, what kind of fossil fuel they relate to. So to give you an example, for example, UK was very forward with this. In the UK, for all investments that were already made before the 3rd of September, which relate to coal, lignite, and peat, which are the most harmful fossil fuels, those investments lose protection immediately or when the amendments enter into force. Then in the EU and in the UK as well, as regards other investments which were already made as of 3rd of September 2025 in other fossil fuels like coal, oil, and gas, there is a phase out for a period of 10 years after the amendments entered into force while they remain protected. And after this 10-year mark, they will stop to be protected. And now as regards new investments, any new investments in fossil fuel made after the 3rd of September 2025 will essentially not be protected. It's slightly more complicated. I'm simplifying, but the gist of it, I think, is this. And unfortunately, the ECT reform is or is not successful depending on who you ask. Some countries withdrew, some countries didn't accept the amendments, so the amendments apply very differently depending on every state, which, however, doesn't really take from the fact that this provision into this fossil fuel mechanism is very novel, because even these novel and new generation BITs, not many of them or not all of them recognize and make difference between different investments in different kinds of fossil fuels. So this is really something quite unique to the Energy Charter Treaty. Anyway, I think I ran out of time. So to conclude very briefly, while we haven't seen any of these novel treaty provisions play out in ISDS, that's because it's very early yet. The important thing is that the groundwork is being laid, and in this I fully agree with what Sadia said at the end of her presentation. And as more of these treaties will enter into force, states will take bolder climate action and disputes will inevitably follow. I think my estimate is that maybe 5-10 years from now, once we start seeing crystallizing these treaties and advisory opinions into real decisions by the tribunals, we will effectively see how these new generation treaties will translate into a new generation disputes, and it will change the nature of the disputes which we're dealing with at the moment. Thank you.
Thank you so much, Lucia. That was really helpful. I'd like to invite the other panelists to see if you have any comments as well. Sadia, if you have any comments, please feel free to chime in.
Do you know what? Just in consideration of time, I'm going to keep it really, really short. Thank you for giving me the floor again. I just thought Lucia's explanation presentation was really thorough. I just wanted to add, because I've been advising the African Union and a number of African states on the revision of their investment treaties, that this is a practice that has been going on for the more than 10 years in Africa now. And I do urge people, please, to have a look at the AFCFTA investment protocol, which is still not into force, but it is a really, really interesting document with a list of very novel provisions, including specific obligations for investors. And, you know, they don't refer to fair and equitable treatment anymore. That's an example of what Lucia has mentioned earlier. They mention a fair and administrative treatment. But in any event, there's a whole chapter on environmental obligations and so forth. So I urge people to have a look, and I'm just going to stop here. And thank you again, Ali, also earlier to make that comment on fossil fuels. I also urge people to have a look at the declarations of the judges, in addition to the advisory opinion itself, because it is really informative, especially with respect to the regulation of fossil fuels. Thank you very much.
Thanks so much, Sadia. Okay, I think we'll move quickly to the last topic. And actually, we haven't decided between Oliver and Judy who will go first. The question's really short. It's some people have said that states' obligations under investment treaties and their international environment obligations are in conflict. Do you agree or disagree, and why? And I know from our earlier conversations, you both disagree. And sorry for spoiling it. But maybe we'll have Judy start and then Oliver will follow.
So I disagree. But thank you for those fantastic contributions and of course for having me. I think what I can perhaps try to do is contribute a slightly different view so that we come out of it with a more balanced discussion. And to answer that question, I think I'd invite us just to take a step back, because we focus almost entirely on the negatives of ISDS today, because we've talked about the criticisms and the reforms when we started off the film. And it's plain, I think, that the system would benefit from significant reform. There's consensus, for instance, that some of the substantive protections are just too broad and too uncertain to be unworkable. But at its core, all ISDS is a mechanism for a foreign investor, when they invest in another country and there's harm done to their commercial interest in that country, for which the state that hosts that investment bears some state responsibility. It's a means of redress for that investor. It's not commercial arbitration, but I would argue it's very much a form of commercially oriented dispute resolution. And it's not really by design, a forum for stakeholders and communities. It's incredibly important that that happens, but that has to happen outside of the very specific operational limits of this very specific process. And as Xiaohan says, I think the reality is that a state will always have different obligations to balance. Private commercial interests, providing a stable investment environment, energy security, human rights, food security, and so forth. And only today, I've been advising a state about a coal power purchase agreement and whether to terminate it. And one of the things we were looking at today was the incredible, devastating impact it would have on that country if you jeopardize the security of power. Manufacture would cease to happen. So these are really difficult choices, and the state has and should have the right to regulate, and they benefit from a huge margin of appreciation in making those really tough choices that they have to make. That's the case in ISDS, it's the case in administrative law, and obviously it's the case in EU law and judicial review. So if a measure is arbitrary, and if it's discriminatory and irrational and unfair, and if a measure, it happens to be disguised as trying to achieve something that in fact has nothing to do with, then I would argue that one of the functions of ISDS is to serve as a check and balance on an unfair exercise of power, and that's a very worthwhile function. And to that extent, again, it's no different to judicial review, it's no different to a breach of EU law and Frankovich damages. These are concepts which we're all familiar with, or even a claim to Strasbourg. So the answer to the question, the reason I disagree is because one could argue that anything which gives an individual a direct recourse to challenge a state's action, gives rise to some kind of conflict, and there's nothing really unusual about that in my view. All ISDS does is just provide a kind of juridical framework through which those assessments and those measures need to be looked at on a case-by-case basis. So, I can see, or I can observe the debate about ISDS being, inherently pro or against environmental protection. Personally, I find the logic of those arguments challenging, because one of the best known ISDS saga in recent decades has been the many dozens of claims that have been brought against Spain in the renewable sector. What happened was that Spain used to have a very generous incentive scheme for renewables companies. It then had a financial crisis, had a budget deficit, it rode back from those renewable incentives, and then it got sued by very, very many companies for damage done as a result of that rowing back of that legislation. So you could argue that if there was a regulatory chill, the regulatory chill is to trying to incentivize Spain to bring back some of those pro-renewables measures. And closely related to that point is this idea that ISDS should be criticized because it offers redress to fossil fuel companies. In my view, that's also a pretty challenging argument on a number of levels, because it's contrary to the principle of the rule of law to suggest that some entities should be just shut out of a legal process because of the industry that they happen to operate in, bearing in mind that what fossil fuel companies do is and continues to be legal until it's otherwise. These are companies that pay taxes, they have employees, they have shareholders, and the investments remain lawfully protected, notwithstanding, so long as the phase out, it continues to not regulate against it. So, I mean, in a fair society, everyone has some recourse to rights, even though it's a society that we might not approve of. If a state infringes on those rights, then those state measures need to be proportionate, they need to be reasonable, they need to be rational, they need to be lawful. So, you know, that balancing exercise is going to be very fact specific, whether a specific measure falls on the right or the wrong side of that balance. And of course, that balancing exercise has been significantly bolstered on one end of the spectrum by the ICJ advisory opinions, because it affirms not just the right to regulate, as Nadia says, but in fact a positive obligation to do that. It's an affirmation of a right that already existed, and a call for a balancing exercise that was always there. So that's my answer to the question. And if you'll allow me a few more minutes, I think that to the extent the future legal voices in this room are thinking about how you want to apply your minds and your passions to making, you know, positive action in this area, I think my personal view is that I think what we need to do as a community is take the environmental argument out of a sort of like nebulous, moralistic, normative pedestal, where it's kind of like slightly elevated and detached from everything else, and put it into the existing framework that is already there. And that was something really important in a case that I did called Client Earth and Shell. I acted for the NGO in a derivative action against the board of Shell, where my clients essentially brought a claim for breach of duty for Shell essentially not having Paris-aligned business strategies. But the critical starting point, we weren't successful. We can talk about that later when I'm ready. But the critical starting point in that litigation was that, you know, the environment is not a kind of independent consideration that's sort of like divorced from the business strategy that directors have like a moral obligation to think about. It is the business strategy. It's fundamental to everything that a company does. Because of asset stranding risk, it's existential for a company like that. Because whether by hard legislation, you know, mandated at the ICJ, or because consumer preferences change over time, you know, there's a serious risk that in our lifetime, fossil fuels would just become totally unviable, and those businesses are going to have to diversify. That's happened to many industries before, see tobacco, and it will happen to industries to come. And if I can trouble somebody to put up this graph that I sent so that I don't have to draw it with my fingers and misdescribe it. You know, the point I'm trying to make is that if a company continually invests in fossil fuel assets, notwithstanding the fact that we know that fossil fuel demand and supply has to contract, then you just risk all of that investment becoming stranded. So I saw it earlier. Yes, there it is. So you can see the point very clearly if you just look at something like this. In climate science, as you probably know, there's an awful lot of scenarios planned. There's also an awful lot of acronyms. But on the y-axis, that's I think that's exojoules. So that's a measure of energy consumption globally. Steps mean state policy. So that's what happens to fossil fuel demands in the status quo. APS means announced pledges. So how much fossil fuel demand there will be if states do what they have pledged to do in accordance with the targets that they've announced, and that is of course net zero. So you can immediately see the gulf between steps, APS, and perhaps more ambitiously net zero. So the argument is that fossil fuel supply and production, which contributes to global supply exceeding the end line and perhaps exceeding the APS line, just risks being legislated against. It's just classic for regulatory risk. And because any prudent commercial operator should know this, they accept that risk when they make the investment. So bearing this in mind, I think the interesting question in this space to ask ourselves isn't necessarily whether or not ISDS is good or bad. Answer is neutral. It isn't really about whether or not carbon emitters deserve protection. Answer, of course they do. It's that if the state does act unfairly and they destroy an investment and they discriminate against an investor, and that investment is a fossil fuel investment, how do you go about assessing the compensation that should be payable to that investor in a world where we are on the precipice of a global policy change? Because arguably in the, you know, just to frame it in legal language, in the non-breach counterfactual, even if the investment had continued, it's more likely than not that there would have been some legislation that restricted that investment in any event and made it unrealizable. And because that's an accepted risk of the investor, the argument would be that they really hadn't no legitimate basis to expect that they were going to be compensated. So no expectation means no expectation loss. I know how boring it is to answer a question by saying, I think the answer is in damages calculations. One can kind of see the eyes glaze over and attention diffuse. But I do think that this is an area where there is a lot of nuance and it really rewards, critical and balanced thinking. So that's why I disagree.
Thanks, Judy. Dr. Hills, do you want to continue?
I will, but just in case there are other views from Lucia or Sadia to chime in.
Go ahead.
No, well, I'll jump into it. Thanks everyone thanks for inviting me, and thanks to my co-panelists for their expert summaries. Judy has focused on some of the procedural and compensation aspects of the question. I also disagree with the premise that investment and environmental obligations are in conflict, but for two different reasons, a concurring opinion of sorts. I think that environmental and investment obligations are not in conflict as a matter of principle, by which I mean as a matter of legal correctness, my take on the applicable law and how it ought to be applied in situations of bona fide environmental regulation. But I want to add a caveat at the end, which is that in practice, maybe the conflict does emerge. The two reasons why I think that in principle, environmental and investment obligations are not in conflict go to the lawfulness of measures to protect the environment, including potentially measures to phase out fossil fuel exploitation. And the second reason goes to the other side of the ledger, namely how investment arbitration might be harnessed to protect the conditions for renewable energy investment over the long term. Sadia and Lucia respectively outlined how general international law on climate change and these new environmental clauses in investment treaties might be brought to bear on climate change disputes. I guess that raises the question, what really is the value of adding express clauses into investment treaties if already you can integrate the general international obligations of states in respect to climate change? And the answer I give in a recent article is that it kind of reminds the arbitrators to take into account the relevant rules of international law regarding climate change. You're moving the rules from outside the text of the treaty, external sources, into the text and context of the treaty itself. So it moves from the periphery, shall we say, to the core of the general rule of treaty interpretation under Article 31 of the Vienna Convention. We have about 3,000 investment treaties in the world right now, not all of them enforced, but about 3,000. How do we approach this archipelago of discrete texts from a principled basis? Well, in my view, you need to realize what investment treaty standards are up to. In effect, they are prescribing the outer limits of sovereign conduct. And sovereign conduct, in its many forms, derives in the first instance from customary international law. So there are various rights of the state under customary international law, not least the right to regulate, which is presumptively lawful if a state elects to regulate for environmental protection. But this right is not free-floating, it has an inherent limit. So the presumptive right to regulate for environmental protection is limited by a claimant coming along and saying, well, no, in these circumstances, the negative impact, or rather the measure was manifestly disproportionate or manifestly excessive, that is to say arbitrary or unreasonable, in light of its negative impact on me and my assets. And in the other instance, we could say that the state's regulation has somehow abrogated a specific promise not to regulate in that fashion. So you have this kind of inherent limit of manifest disproportionality and this consensual limit of specific promises not to regulate. From this starting point, I think it's worth exploring a couple of instances where we might have the state's right to regulate tested. The first is if the state imposes kind of general regulatory environmental measures. I think it's going to be very difficult in light of the duty of the state to regulate in respect of climate change for an investor to show that the impact was manifestly disproportionate, because you now have the state not simply electing to regulate, but they are obliged by international law to regulate. It's important to note that this isn't wholly untested. If you go back to a case called Chemtura in Canada from about 2008, I believe, you have a very distinguished tribunal finding that a measure to ban certain agricultural pesticides was neither an expropriation nor a breach of the fair and equitable treatment standard, because Canada was simply regulating in light of its international obligations, namely its obligations under the Stockholm Convention on Persistent Organic Pollutants. So these are not uncharted waters. So that's kind of general environmental regulations. What about kind of specific projects, proposed activities? Well, we've heard already from Sadia that the International Court of Justice has given guidance on environmental impact assessment. In the case decided earlier this year, Discovery Global and Slovak Republic, we have a case where the tribunal found that the investor did not have a legitimate expectation that its oil and gas drilling activities wouldn't be subject to evolving environmental impact assessment requirements, because the Slovak Republic was obliged under EU law to implement those evolving requirements into its municipal law. And I think this type of reasoning applies even stronger when we're thinking about the state's obligations under public international law, the stringent duty of due diligence affirmed by not only the International Court of Justice, but other international courts and tribunals. As we have more and more domestic and regional courts admitting that it's necessary for states to take into account Scope 3 emissions and environmental impact assessment, we have the UK Supreme Court in Finch, we have the High Court of Guyana, we have just recently the European Court of Human Rights mentioning this in passing. I think it's relatively comforting for those who are proponents of environmental protection that investment tribunals exercise an incredibly high duty of, incredibly high deference towards judicial decision making. To quote briefly from a recent case called Montauk Metals in Colombia, judicial bodies across the globe are widely recognized to validly lead the way in the development of the law according to society's evolving values. I think that's particularly apposite in the first exit claim that's been brought against the United Kingdom in respect of a decision not to approve a deep coal mine in West Cumbria. I think the most delicate issue, as compared to general regulations and specific project proposals, is the question of the abrogation of contractual rights. Say a state decides to legislate to terminate power purchase agreements with coal power plants, or it decides to terminate offshore hydrocarbon concessions. Traditionally, these would be quintessential breaches of public international law, even before the rise of investment treaty arbitration. The idea is that a state shouldn't step out of its shoes as an ordinary commercial party and use its uniquely sovereign powers to extinguish private commercial rights. However, if we look at the past practice, usually it's opportunistic abuse of sovereign power so that the state can claw back control of those natural resources or industrial assets for its own benefit. And with fossil fuel phase-out disputes, we're thinking about the abolition of the industry, or at least over time. And in some of my own research at the moment, I'm looking back at practice in the 19th century, the early 20th century, around the abolition of slavery. There were judicial decisions at the time, international claims commissions decisions, where they found, well, no, that a certain claim was inadmissible because now the African slave trade is contrary to the law of nations. There is a logic, I think, to be derived from some of these decisions. And indeed, in mid-century debates around the nationalization of natural resources, often in doctrinal writings, you see people like Eduardo Arriaga, he was the ICJ president in the 70s. You see his writings in the 60s contrasting these abolition type measures with the nationalization of natural resources. And that's important, I think, in drawing the line between compensable expropriation and reasonable regulation to draw on this rich experience of public international law. So that's the first reason why I disagree with the conflict. I think that public international law, the proper interpretation, application of investment treaties, allows for the bona fide regulation of the state to discharge its duty of due diligence, and that might even extend to the sovereign abrogation of contractual rights to phase out existing fossil fuel infrastructure. Very briefly, the second reason is that investment treaties might support this cardinal problem of political economy in the energy transition, which is to decarbonize global electricity production. And to do so, investors in renewable energy need long-term stability, both in the price of renewable electricity and in the regulatory conditions. And already Judy has alluded to or described to you the wave of cases arising from the withdrawal of feed-in tariffs, which were a form of subsidy for renewable electricity. But now most renewable electricity is actually having to trade on the unsubsidized market. So investment arbitration and I think commercial arbitration can provide a powerful role in promoting those basic legal conditions for private investment and decarbonizing decarbonizing the energy industry. My final caveat, however, is that investment arbitration is prone to uncertainty and one might even say incorrect legal decisions because it's based on party-appointed arbitrators and there's no right of appeal. So if there are mistakes in the identification and application of law, the decision stands, and sometimes the award of millions, billions will be enforced regardless. So I do think that in aligning arbitral practice with this obligations of states in respect of climate change, the law of treaties does permit states to withdraw protection from fossil fuel investors, whether it's through the modernization of the Energy Charter Treaty, even through the bilateral modification of multilateral investment treaties. And at the end of the day, I think we need to keep in mind that whatever the financial risk of investment arbitration, the investment gap to achieve net zero emissions by 2050 is about $5.5 trillion US. So that is the real goal, is to finance energy transition, in particular through international cooperation and climate finance to those fossil fuel dependent countries that are finding it hardest to phase out. And on that note, I would say that investment arbitration is part of the picture, but it's certainly not the sole cause of the problems being faced at the moment.
Thank you. Thanks so much to Oliver and all our panelists. Actually, maybe I'll just pause there to see if anyone had any comments on what Oliver said or what Judy said from Lucia or Sadia. Okay. So I've gotten a note from the organizers who have noted that we're running very, very over time. I think we're like 20 minutes past our schedule. So we've decided to skip the breakout session. So we'll do the Q&A, the audience Q&A for about 10 minutes until 8:30. And then I think we'll have our break and then the pub. which sounds like a great plan to me. So yes, please ask your questions either in person or online. Yes, gentleman in the middle.
Thank you. I just had a couple of thoughts. Firstly, when you were talking about sort of similar remedies that are available in other contexts like judicial review, why there should be a difference between the remedies available to ordinary citizens and the remedies available to investors. And secondly, I recently had a look at Dr. Hill's article on the concept of unjust enrichment in potentially, to my understanding, sort of neutralizing the damages that might arise from investments that, for example, would have breached the Paris Agreement. And I'd be interested to hear any further thoughts you might have on that.
That was
Yeah, go ahead.
Yes. Yeah, I mean, so judicial review is a different process. I think the point I was trying to make, perhaps badly, is that we don't live in the kind of society where if you are a fossil fuel company and we don't like what you do, that means you can't bring judicial review as a means of checking, you know, what might be an infringement of your rights. So, in a previous life, I when I was a sort of very junior lawyer, I had some involvement in the judicial review about plain packaging. So that's the law that brought in the packages that we have now, which are brown and green on cigarettes, and they took away the sort of fancy sparkly logos or whatever. And even in the context of that kind of litigation, which you might say is brought by countries that are companies whose businesses we just find abhorrent to human health, you know, there was no suggestion that you know, they don't have property rights or their trademarks don't deserve protection, or you know, that somehow they should be subject to different laws and different rules, you know, simply because we don't like their business. It was an assessment of the rationality of the measure. So can you, you know, on an, you know, in an econometrics analysis, for instance, actually link the legislation to the stated aim of the deprivation of the trademark, which was to reduce smoking. So can we test, you know, can we have a conversation testing, you know, the soundness of that measure? And that's, as I was trying to make the point, a very, you know, case by case analysis. And my view is that there's no reason why that kind of approach to assessing something, you know, bona fides shouldn't also apply to an ISDS system where we can look at state measures and allow that to be checked. Subject, of course, to Ollie's point, which is that, you know, arbitral tribunals can't be trusted to get the law right. And
Oh, some of them can. I'll follow up on that point about the unjust enrichment. So I think that there are different arguments available in applicable public international law that can intervene at different stages in the valuation of compensation to reduce the claimed amount. There's a piece I wrote on unjust enrichment. There's another chapter I wrote on the valuation of compensation in fossil fuel phase-out disputes, in which I tried to go through and say, well, whether it's, you know, identifying what was the breach, drawing a causal link between that breach and the claimed injury, choosing the appropriate valuation method, applying the valuation method. So in terms of what are the future cash flows expected from this income producing asset, for example. So, you know, you can unbundle it into about, I don't know, 6 or 8 important stages. And it's not a purely economic exercise. It's framed at every stage by law, by international law. And as a final footnote, I end that article by saying that the eye-watering damages that are predicted by vocal critics of investment arbitration, often relying on industry valuations, are far from fait accompli, because you need to actually approach it from a legal perspective. And this idea of the regulatory chill, I think it's a phenomenon that we collectively construct as a legal community. And I think sometimes the expected risk of ambitious climate measures is overstated by, say, the NGO community, and that might actually have the inverse effect that they are driving towards.
Thank you. We had a question. Was there a question over there? Okay.
I have a question regarding the relationship between the state's obligations under the, well, it's not under the advisory opinion of the ICJ because that is an interpretation, right? And legitimate expectations. And why? Because of the timing, because in a way, the advisory opinion is saying that states are already obliged or were obliged since the existence of each of those bodies of international law that are included in the advisory opinion to do certain acts, regulate or whatever. But on the other hand, it could be said that the legitimate expectations of the investors existed before this given moment. So what is it that I want to say? That is only from this moment on that it could be said that the investors do not have a legitimate expectation of not being regulated, but the states are obliged already to regulate. So how do you think that clash between these two concepts might develop?
Yeah, I think that's an excellent question, and I think that's precisely the kind of area where there will be a lot of argument, and you can see that it's highly arguable either way when it comes to a tribunal having to do a damages assessment. I would challenge I mean so let's see what kind of arguments Lucien, Sadia and I and others come up with, but I would challenge the idea that until the advisory opinion you were sort of a carte blanche as to what you could and couldn't invest in with security that it wasn't going to be legislated against. It's been 10 years since Paris, and in fact there's a lot of case law, sadly not in this country, but in the Netherlands for instance, where there have been very good analysis finding establishing a juridical basis for why it is that companies have specific obligations to reduce their emissions, and therefore conversely an expectation that they can't just continually be pumping fossil fuel supply into the world.
And I think this also goes to what are those legitimate expectations? Because if you frame it as a question of does the investor have a legitimate expectation that the state won't regulate, then I will tell to you, no, it doesn't. And probably no tribunal would frame it in that way and say that this is what legitimate expectation is, because it's not. And then there are more broad and more narrow ways of construing this. But typically what we're seeing increasingly is that for legitimate expectations, there must be some sort of representation made. And then it's a question of how general is that representation? Is it a representation made by the state to all investors or to the industry, or is it a very specific representation made to a specific investor in a specific sector with respect to a specific project? And if a state comes to you, say let me play the devil's advocate. Say I'm a fossil fuel investor, even in coal, for the sake of the argument, and I have a state coming to me saying, we're struggling with energy. We need more energy. Despite the fact that you're a coal investor, I promise to you that you can run this project for 10 years because we're so desperate and we need energy, despite Paris Agreement and everything. I promise to you. And on the basis of that promise, you make the investment, invest in infrastructure, put lots of money into running a project. Then you can say you have legitimate expectations that the state won't govern against you. I push this too much. Obviously, this probably won't happen in the real life, but this is kind of just to see how legitimate expectations work. So you can't, I think it's unrealistic to expect somebody to say, no, you won't regulate under any circumstances. That's way too broad. But then there's more specific circumstances where state officials made representations to you, which led you to believe that your project will have a future. And then we can discuss in cases whether having an informal dinner with some sort of state official somewhere is, really a state representation. Then it's a full colored scheme, but it's it's about how you frame that. What is and what is not legitimate expectation.
Yeah. A whiskey in the hotel
Oh, yeah.
lobby of the capital. That's always one of the legitimate.
Can I just add a quick comment, if that's okay? I actually have a question in response to that question, because I really like, that we're debating on legitimate expectations and what would qualify legitimate expectations or not. I think that's a very interesting point. I'm also questioning myself on how are we going to interpret stabilization clauses moving forward. All the panelists, I think, said that an investor cannot expect a total freeze of regulatory changes, especially with respect to the environment now. I think I heard that from everyone on the panel. And so in this instances, if you have a contract with a stabilization clause, I'd be interested to see how tribunals will move forward in interpreting those stabilization clauses in the future, if there was an argument made with respect to no regulation in terms of environmental policy and environmental law. But that's, sorry, it's maybe not helpful, but it's food for thought for all the people in the room, and maybe panelists have an answer on this, my co-panelists. But I'm really looking forward to seeing the impact of the advisory opinion on decisions, with respect to not only investor treaties interpretation, but contract interpretation as well. Because let's not forget that investor-state arbitration also arises under contracts and under domestic legislation, under investment codes, if you have consent to arbitration. Maybe just a mini point, because I know we're running out of time, but I heard all my co-panelists, and I thought, there's a billion interventions. And one of the things in particular that was said earlier on the last question that was asked was, well, do you know what? The ICJ just clarified things that already existed. And arguably, even under the old generation BITs, where there's no specific reference or specific language to the right to regulate in terms of environment or obligations of investors, these would apply and exist and so on. I would say yes, in accordance to all the points that, Oliver had made in particular. And I really like his article, and he's too humble. He didn't refer to his excellent article that I'm gonna talk about just really quickly on environmental clause in investment arbitration, deep roots, green shoots, and deadwood. Please have a read at this, a really good article. But what I wanted to say on this is, as someone who advises states and also investors, in fact both, none of these parties want to go to investment arbitration and argue about this. So can we please just all agree that it would be great if we had more certainty, and that we reform the existing stock of bilateral investment treaties, which 85% of them have been signed and drafted in the 90s. And if we can all agree on that specific language clarifying this would be great, then I think it'd be really nice for the future of investment disputes to spend less time arguing about this. So I'm just going to stop this. Thank you very much.
Can I make one quickly? I'll be very brief. Thank you very much, Sadia, for that shout out. The only point I would say is that we shouldn't be too quick to reify or crystallize the notion of legitimate expectations as if it's an investment treaty standard in its own right. I think we've passed the high watermark of legitimate expectations reasoning in investment arbitration. If you look at Eurus in Spain, one of the last awards in which the late James Crawford was president, there's a great phrase that legitimate expectations are essentially consideranda in determining whether the measure was disproportionate. Something to take into account. And if it's just something to take into account versus the stringent duty of due diligence recognized by the ICJ, I think it's clear where the merits land.
All right, thank you. Thank you so much to all the panelists. I've been told we only have time for one more question, which will come from online. I don't know how that's... Oh, you're going to read it out.
I'll just read the first one that came in. So could a state sue another before the ICJ for the latter's refusal to reform existing BITs to make regulatory powers compatible with the ICJ and ITLOS's climate advisory opinion? And that's open to the floor, obviously.
There's an interstate arbitration between Ecuador and the United States from years ago, where it was around the United States' refusal to make kind of a joint clarification of the meaning of certain investment treaty standards. So you have kind of interstate cases before where it comes down to the kind of disagreement around how to clarify, if not reform, investment treaties. To bring a case before the International Court of Justice on this sort of issue would be quite strange, in my view.
And also the states which don't like their current BITs can always unilaterally terminate them. There are sunset clauses which will apply, but they have the right to terminate if they don't like them. So that's one thing they could do.
Okay, and I think on that note, that just leaves me to thank our panelists, as well as Sadia coming in from DC, Oliver, Judy, and Lucia. Thank you so much. Let's give them a round of applause. And I think we're just going to break for the pub. Everyone's welcome to join us. Thank you.
Thanks so much,
Thank you, everyone. Thank you. Enjoy the drinks. Bye.
Thank you, everyone. Just before we break, these are the discussions that we'll share also in our closing email, so that you can continue thinking about this. And yeah, just to let you know a bit more about how you can help LVF out. You can share about us on LinkedIn. You can share about our events with your friends, volunteer your time for us as well. And these are just some QR codes that you can scan. And our next event is on 9 December on climate protests in the UK. Please do save the date if you want to come. In this room with GRI, our valued partner. Thank you, everyone. Also, the bar is all bar 1 at Holborn in case anyone is lost, but we'll hit that together. Oh, and you don't have to drink to enjoy your time at the pub, so join us, please.
Words like ray of fire. It's too complicated.
I think the only thing